Today I'm going to teach you about a US Supreme Court decision in 2005 called MGM Studios versus Grokster. Here are some facts to get you started. The appellant, MGM Studios, held copyrights to a lot of different types of creative works, like audio recordings, TV shows, and movies. MGM sued the respondent, Grokster, for infringing these copyrights. Grokster distributed free computer software, which allowed users to upload and share electronic files directly to other users. This is called a peer-to-peer network. The problem is that people started using the software to share files that were infringing copyright. But hold on a second. If Grokster never directly infringed MGM's copyrights, then why did MGM sue Grokster instead of the users? Well, MGM never claimed that Grokster directly infringed their copyrights. Instead, MGM wanted Grokster to be found liable for contributory infringement. This fits under the broad heading of secondary as opposed to direct liability. To establish contributory infringement, a party must have knowledge of the infringement and must also materially contribute to the infringement. In the lower courts, Grokster was able to avoid liability for contributory infringement. This is because Grokster was specifically designed to avoid this kind of liability. They were found to not materially contribute to the infringement because as soon as they distributed the software, they lost central control over it. This means that they couldn't kick people off the network, and they also couldn't remove infringing files. They also successfully argued that they didn't really have knowledge of the infringement because they only found out about it after they'd already lost control of the network. Additionally, Grokster relied on a previous decision by the US Supreme Court called Sony versus Universal City Studios. This case basically said that as long as software designers like Grokster could show that their software was capable of substantial non-infringing uses, then they would not be liable for contributory infringement. As a result, Grokster was feeling pretty good about itself when the case was appealed to the US Supreme Court. But not so fast. The Supreme Court disagreed with the lower courts. They wanted to place a balance between promoting the creation of new inventions and the protection granted by copyright. They felt that the best way to achieve this balance was to place more emphasis on the intent of Grokster when assessing contributory liability. As a result, they created a new method to find secondary liability for copyright infringement. This new method was called inducement of copyright infringement. Inducement is all about intent. To be found liable for inducement, all you need is to distribute a device or software with the intent of promoting its use to infringe copyright. So how do you prove intent? Well, intent can be established by evidence of a clear expression or other affirmative steps taken to foster infringement. In this case, three pieces of evidence weighed heavily against Grokster. First, Grokster intentionally marketed itself towards Napster users after Napster was shut down. Napster offered software that was very similar to Grokster and was found to promote the infringement of copyright. Second, Grokster actually distributed information about how to locate copyright infringing files on their network. Finally, Grokster intentionally avoided preventing copyright infringement from occurring on their software. So in the end, MGM wins. Grokster was found liable, and the test for secondary copyright infringement by inducement was born. Any questions?